Oh man, I just realized that we weren't even the mics weren't even on. The mics weren't even on. So I was, I thought I had a a friend, but let's get into this. State versus your trust. If you're watching, we're likely going to pull that down, redo it, cut that off. Just realize that the mic was not miking. But this is the foundation. I am Sot L, seeker of truth L, speaker of truth L. And I would like to welcome you to another episode. Today's episode is any state versus, quote, your trust, end quote. Oh, man. Sorry, y'all. Now what? So, this stuff happens. You may deal with something, but ultimately, let's just get into it. What now? I want to welcome y'all to the foundation. Apologize, we be having mic-micings. But here, once you pass the point of belief, you enter into action. Let's just do it. The phrase "you can do it" or "you got this" or "I believe in you" when you're learning how to ride your bike was empowering. When administering trust, there are rare times a challenge is made. More often than not, it is from a state or some representative of the state. So today we will discuss how to be successful and remain in honor at the same time when dealing with a litigational challenge. I don't think this is talked about enough. I do want to say before we get started, I am not a lawyer. I am not an attorney. I do not give legal advice. I do not give tax advice. I do not give trading advice. I do not give wealth advice. I do not have the credentials required to give legal advice. Although I do speak on my knowledge and my experience, if you need legal advice, you need to consult someone in the legal field, such as an attorney or a lawyer. With that being said, let's jump into the show. Let's get it right. Let's get it going. Appreciate y'all checking out the show. Make sure you check out welcometothefoundation.com. Sign up for the email list at the very least. We very much appreciate it. Here's the box. You can sign up for the email list right here. Your email right here. We appreciate it. Exclusive offers, events, newsletters, updates, so on and so forth. Only to those who sign up for the newsletter. We are still, until next week, Friday the 13th, running our offer of 50% off your startup fee for trustee training, trust administration, trust creation, trust enforcement, trust protection. We have the silver, the gold, and the platinum. I do want to point out that the platinum includes my private mobile number. It's not a gimmick. It's not a Google Voice number. And I just say, hey, just give me a call. There's a lot of things you're going to deal with. Just give me a call. I'd rather you give me a call than shoot me a text. Even if I miss your call, I still have your missed call in my call log. If you shoot me a text and maybe I'm already texting someone or I'm getting directions or whatnot, and I accidentally tap it but have to go back to doing what I was doing, so, I may forget about that text. And I'm just speaking from experience. It's happened. So I rather people call me and people say, oh, you're busy. It's not for you to determine if I'm busy. It's not for you to determine what is considerate to my schedule. If I say that you should call me, you're in trustee training, you should call me when you have a question. It's not for you to consider what a question to me is stupid or irrelevant. I consider no question stupid unless you already know the answer and you're being facetious. But even then, it's still a question. It's not stupid. So just give me a call. But half off to sign up for a platinum membership with my personal email, and you're learning trust administration, and you have access to the training, and you have the trust. It's a lot. And if you can't be successful in that specific situation, then we're just gonna work harder. How about that? We're just gonna work harder. But silver, gold, platinum, 50% off the startup fee. Email us though, admin@welcometothefoundation.com or support@welcometothefoundation.com. And you'll be taken care of. You'll be sorted. You'll be sorted. We'll be happy to have you as part of the foundation family. I do want to chop it up about silver. Silver, dollar cost average. Silver is money. Gold is money. Check Article 1, Section 10 of the Constitution. We do have, currency. That's what's up. But we have silver. Looks like it's trading a little sideways. Did take a 30%, 40% drop at one point. Dollar cost average, no matter what it is, $25, $50, $100. You want to regularly, whether it's every 2 weeks or it is every month, take that $25, that $50, and go to a We Buy Gold spot or a coin shop. Talk to them. Be nice. Develop a relationship over time. And dollar cost average. Hey, I got $25. What can I get? I've got $50. What can I get? What can I get this week? What can I get this month? And before you know it, you will be building up. It's the easiest way and most economic way to do it. It's how I started. And from experience, it adds up, and it adds up quick. There are fractional pieces of silver, 1/10 of an ounce, grams, quarter ounces, half ounces of silver. You can find a lot of different. So you don't have to get a whole ounce. If you can, do it. But, just regularly, because we are in the midst of not only a geopolitical, functional change, but also an economic change, functionally. And it will become more and more apparent as this year and the next few years roll on. So with that being said, I'm going to jump into the show, right? So a lot of people will start dealing with trust or get this very phantasmagorical view of what trusts are and what they can do and how you, whatever, right? But I tell trustees in training that in particular, two of the most important things with the trust is the inception or creation of the trust, and is it valid, and the administration of the trust. How is it operated? It's very simple. I know a lot of people try to complicate trust administration, but that is very simple. In the administration, don't self-deal, don't commingle, but you get into deeper waters with that. And I understand that, comprehensible. But we have the inception and administration. So I'm going to speak on a specific case. I have the case pulled up, but first I want to reference the Foundation magazine black and white issue from October 2024. The layout, man, the ultimate, in my opinion, the layout and production of this magazine was way ahead of the time. But, my guy D, shout out D. But real quick, Carriage House Trust, and this isn't even that long ago. This is in the 90s. We've got case law from the 80s, the 90s, 2000s, 2020s. We got case law with regards to trust from the 1900s. the 1800s, late 1700s, 1600s. It goes back. But this is just one because, people be like, well, you show all these old cases. It's old. That doesn't matter. And some people will say it about this. But the principles still remain. So in reference, in the legal landscape, the administration of trust stands as a cornerstone of modern fiduciary practice, exemplified vividly in the precedent set forth in the Carriage House Trust Supreme Court case. This landmark case decision underscored the pivotal advantages inherent in trust structures over conventional individual ownership paradigms. And that's what most of us are in right now, the individual ownership paradigm. And it's a diabolical paradigm. It's evil genius. I'm just going to tell you. If you can't see it, you feel it. I know you feel it. If you can't see it, you can't conceptualize it. And if you can't conceptualize, you can't articulate it. Here at the foundation, we're trying to help you see stuff and help you with your concepts. Your articulation is on you. Your administration is on you. Encapsulating profound implications for estate planning, asset protection, and intergenerational wealth management. Multi-generational, intergenerational. Multi-generational or intergenerational wealth starts at 300 years, just by the way, multiple generations before you have a house. The house of, what's your family name? It sounds cool, doesn't it? What's your last name? Moore? The house of Moore. Ooh. What's your last name? Williams? The house of Williams. Ooh. That sounds prestigious. Fundamentally, the efficacy of trust lies in their capacity to transcend the limitations of individual ownership. Unlike direct ownership, which often entails singular control and immediate tax consequences, trusts establish a nuanced framework wherein assets are vested in trustees for the benefit of designated beneficiaries. This division not only safeguards assets from potential individual misadministration, but also fosters a structured approach to wealth succession and preservation. Preservation in this specific episode of the foundation being key. By placing assets under fiduciary oversight, trusts imbue a sense of continuity, ensuring that the intentions of the settlers are meticulously adhered to across generations. Moreover, the Carriage House Trust case illuminated the substantial tax benefits conferred by trust administration. I didn't say that. The courts say that. I legally can't say that. I can lawfully say a lot of things, but legally, and a .com is legal, not lawful. You feel me? But I can lawfully say what? I can lawfully say what? let me quit playing. Through strategic planning and allocation, trusts facilitate efficient tax mitigation strategies that mitigate the burden of estate and gift taxes. By leveraging mechanisms such as grantor trust or charitable remainder trust, settlers can achieve substantial reduction in tax liabilities while concurrently advancing philanthropic endeavors. But we don't deal with them grantor trusts over here. But hey, if you don't know about private trust, a grantor trust is adult because it protects from probate, but it doesn't protect against litigation, as you'll see if you study. But here, this is the point. Additionally, trusts offer unparalleled asset protection mechanisms, shielding assets from potential creditors and litigious adversaries. By vesting legal title in trustees, trusts insulate assets from personal liabilities that might jeopardize, like a personal liability such as a bankruptcy, an individual bankruptcy. Jeopardize individual ownership structures. Yes. In your individual ownership paradigm, bankruptcy affects everything that individual owns. Everything. All of it. And the court gets to decide what you keep and what you can't keep. And the crazy thing is like Man, I already paid for this stuff. These are other bills, like a home I couldn't pay or a credit card I couldn't pay off or something like that. And you gonna take the stuff I already paid for? Let's get into this carriage house, right? So this is the carriage house case. And you got the carriage house United States District Court of, Vermont, in regards to the carriage house versus, it's funny because you got the carriage house as the debtor, right? And you got the carriage house. Yeah, let's get into it though. Okay, so I'm just gonna tell you this. So this top part is the individual side, and all individuals are represented here. These are the actual bankrupt individuals, the debtors. This right here is going to be the, let's say, the entities, the other entities, right? So this is James Gablehart, Ruth Gablehart, James Gablehart as trustee, of C&H Associates, which is the trust. Then you got the First National Bank, right? So they're named as trustees of the trust. So that's the entity. You have the National Bank of Vermont. You have the General Electric Capital Corporation. You have the Carriage House Incorporated. So the actual trust, the trustees named as, individuals, but as trustees, and you have the actual trust named. Then you have the trustee, John R. Canny, who is the trustee for the bankruptcy estate of James Gablehart and Ruth S. Gablehart. So this is the trustee for the individuals. Let's just say that. So the individuals who are claiming bankruptcy, this is the trustee. So on behalf of the individuals who are filing for bankruptcy, this guy, acting on behalf of the bankrupt individuals, is trying to go get property that the individuals put in trust. But, he's doing them a favor. Look, determination was sought that declaration of trust executed by Chapter 7 debtor trustee was invalid. So this guy, John R. Canny, these people on the bottom, and this stuff don't want to highlight the way I want to, but the bottom, there we go. This group of people, which is not people, this group of persons, I apologize for that, right here. But really, John R. Canny, the third trustee, he's seeking determination that the declaration of trust was invalid first. Okay, so that tells you something right there. You have to invalidate the trust. So there's obviously some power in trust, and that the trust property was a part of the debtor's bankruptcy estate. So this guy, he's the trustee for the debtor's bankruptcy estate of James J. Gablehart and Ruth, and they're married, so they have a marriage certificate, and we can get into that on a different show or something like that. So she's looking to have a determination with regards to the trust being invalid and the trust property was part of the debtor's bankruptcy estate. The United States Bankruptcy Court for the District of Vermont, and this is the case right here. 120 BR 754 Francis G. Conrad. That's probably the administrator or the judge. J. Held that the trust was valid, and the appeal was taken. The district court, Coffin Senior District Judge, held the debtor's attempt at creation of common law business trust, even if imperfect, would nevertheless result in creation of some entity, the res or property, of which was excludable from the bankruptcy estate. This was affirmed. So we already know that the trustee was unsuccessful. But let's get into the background. Bankruptcy trustee John Canny has appealed the United States Bankruptcy Judge Conrad's findings regarding the status of the Carriage House property. The appellees are Arthur Liu and Nancy Liu, the Lius, who hold mortgage on the Carriage House property and the First National Bank of Vermont. So there's a mortgage involved as well. The appeal was docketed in this court. Also, there's a trick that they throw in the end, right? with regards to the witnessing, saying that they weren't together. Oh man, it was a dirty. I saw it as a trick. I saw it as dirty. We'll get to that though. I'm gonna go through this. I ain't gonna take too much of y'all time. The appeal was docketed in this court November 19, 91. And on December 5th, 91, the bankruptcy trustee filed the appellant's brief, and the next day, the printed case. The Lews filed their appellee's brief on December 20th. First National Bank of Vermont filed the appellee's brief on December 23rd. And the bankruptcy trustee filed his reply brief on December 30th. Both the appellant's brief and appellant's printed case technically should have been filed December 4th, 1991. Appellate courts, they do not play. They're sticklers for procedure, and they point out procedural defects even if it doesn't matter for the watch. Where was I at? I lost my spot. Here we go. Both the appellant's brief and the appellant's printed case technically should have been filed December 4th. Which would have been 15 days after the appeal was docketed, bankruptcy rule 8009. However, a late filing of brief is not a jurisdictional defect. So, hey, whatever. It's not our problem, and we choose to consider these papers even though they were not timely filed. So there's a basically they're mentioned in latches. Like, you know, you have so much amount of time to come back. Okay, May 1st, 87. So this is years prior. James Gablehart signed a long document styled as a declaration of trust of C&H Associates. The declaration of trust, and it was defective. That's what I want to tell you. And even though it was still defective, it's still counted as an other, quote, entity, end quote, according to the bankruptcy code. Just want to say that. It appears that he did this because his accountant told him that setting up such a trust, which the accountant erroneously thought would qualify as a real estate investment trust under 26 USC subsection 856, would save him money on his federal income taxes. Judge Conrad analyzed the contents of the declaration of trust in detail and found that it purports to set up a business trust. Also, May 1st, same day, James Gablehart purchased the carriage house property from the Lews. The Lews gave a warranty deed to Gablehart, and Gablehart gave a mortgage deed to the Lews. Gablehart was identified in both deeds as James Gablehart, trustee. And this happens, you'll see this in land records. You'll see a person's name, comma, trustee. That's for privacy. They're not looking to divulge the name of the trust. They don't have to. Entitling property at the county level in the trustee's name, comma, trustee is sufficient enough, and we'll see. We'll definitely see. Both these were recorded in Windsor Town Clerk's office, but the declaration of trust was not because it was private. You don't record your trust indenture. Matter of fact, if the trust indenture is properly crafted, there will be specific language in the indenture itself, which states broadly that if this trust is recorded in any county or state recorder or made public, it must be immediately dissolved. It must be destroyed because it's private. And this is why you read case law. You learn stuff and other stuff is affirmed. Okay. At present, the holders of the beneficial interest in the C&H Associates Trust are James Gablehart and his wife, Ruth. So him and his wife are beneficiaries. That's a key point. The Lews assigned the mortgage deed to First National Bank as a security for a loan. Thereafter, the Lews paid off the loan and requested the return of the mortgage deed. Because he failed to realize that the mortgage from Gablehart to the Lews had not been paid off, Carol Cooley, a First National Bank manager, inappropriately noted on the mortgage deed of the debt. That the debt had been paid in full and the mortgage discharged. Donna Simmons, pay attention, an assistant bank manager, also executed the mortgage discharge as a witness. The facts indicate that Neither Cooley nor Simmons saw the other actually sign the discharge. This is very important. The discharge was duly recorded in the town clerk's office. Realizing its mistake, First National Bank subsequently attempted to cancel the discharge on October 24th, 1988. However, on August 1st, 1988, James and Ruth Gablehart had filed a joint Chapter 11 petition. So they tried to cancel the discharge in October, but in August, 2 months prior, they had filed Chapter 11 debt protection. Carriage House Incorporated, the corporation using the Carriage House property. So the property was in trust and there was a corporation utilizing the property. Very important. Very, very important. This is how we do it. This makes so much sense to me. And, you know, I want to say rest in peace, Tony Franklin, my mentor. Man. The corporation had also filed Chapter 11 protection on February 2nd, 1990. These filings were converted to filings under Chapter 7. So you got Chapter 7, Chapter 11, Chapter 13. There's other chapters. I don't know, you know, those are the chapters that, you know, I believe are the only ones that relate to individuals, but I don't study bankruptcy code. The C&H Associates Trust has not filed for bankruptcy, and the trust wouldn't file for bankruptcy. Why would it? Why would it? It's private, and what debts does it have? It has none. Bankruptcy Rule 8006 provide that the appellate shall file with the clerk and serve on the appellee a designation of the items to be included in the record on appeal and a statement of the issues to be presented. The appellate here presented one statement of the issues on appeal with his notice of appeal and designation of the items on the record on appeal, the first statement, and a different statement of issues as part of his brief, the second statement. The first statement reads as follows, and this is what they're asking the court. Did the bankruptcy court error means error, in holding that property described in Book 87 at pages 193 to 194 of the land records in the town of Windsor, Vermont, was not property of the bankruptcy estate of James? So you're saying, so you said that this property was not property of the bankruptcy estate. Were you in error? That's the question. Did the bankruptcy court err in holding that James J. Gablehart holds title to the above property referenced solely in his fiduciary capacity as trustee of C&H Associates, an entity other than the debtor? So basically, are you sure that this guy holds the property as trustee only in fiduciary capacity and not in his individual capacity? Are you sure? Did you error in saying that he didn't? Did the bankruptcy court error in holding that the declaration of trust executed by James J. Gablehart created a valid Vermont common law business trust or private trust? So they're attacking the validity of the trust entity, and the validity of the trust entity is not to be challenged. It is not to be challenged. Not in the way that we execute or teach the way we execute trust here at the foundation and how we teach trustees to execute trust is not to be questioned. And, it's not. By contrast, the second statement reads, did the bankruptcy court err in holding that the declaration of trust of C&H Associates created a valid and non-voidable Vermont law business trust, or in the alternative, a private trust? And people be like, oh, ain't no such thing as a private trust. Okay. Did the bankruptcy court err in holding that the real estate and building located in Windsor, Vermont, at which the Carriage House Incorporated did business, was not property of the bankruptcy estate of James or Ruth Gablehart, as James J. Gablehart holds title to the property solely in his fiduciary capacity as trustee of C&H Associates? This dude's tripping. I mean, he tried, man. Yeah, he did it. You know, he tried. Did the bankruptcy court err in not addressing the mortgage discharge issue? Bankruptcy Rule 8006 states that the issues of the appeal are those presented with the record on appeal. And this is where I'm telling you, the court will point out your procedural defects, even if it doesn't matter, which in this case would be the first statement. It is unclear whether an appellant should be permitted to amend his or her statement of the issues of the appeal in his brief. However, the appellees have raised no objection, so they didn't object to him raising issues in the brief. So the raised no objection to appellant amending his statement of the issues. Furthermore, since the issues in the second statement were briefed in the appeal, it is more convenient to address the issues in this format. So we got merits of the case here. Merits of the bankruptcy trustee appeal. United States District Court must affirm bankruptcy court's finding of fact unless such findings of fact are clearly erroneous. Conclusions of law, however, are reviewed de novo. Like, new, brand new. Bankruptcy Rule 8013. Judge Conrad found that Carriage House property was the res of the C&H Trust. He further found that the C&H Associates Trust was a valid common law business trust, or in the alternative, a private trust, and that James Gablehart was the sole trustee in this trust. He therefore determined that any power exercisable by James Gablehart solely as trustee of the C&H Associates Trust could not bring the res of the trust into the property of James Gablehart Estates on account of 11 U.S.C. subsection 541b1. So basically, just because I'm the trustee of the trust, you can't associate ownership of the trust property, the property the trust owns, to me personally. Judge Conrad's analysis of the issue will be further discussed below. The bankruptcy trustee first disputes that a valid trust was created. He next disputes that James Gablehart held the trust solely in his fiduciary capacity as trustee. Finally, he argues the bankruptcy court erred in not discussing the mortgage discharge issue on appeal. We address these three issues in turn. A, was the C&H Associates Trust a valid business trust or private trust? On appeal, the bankruptcy trustee disputes Judge Conrad's holding that the declaration of trust created a valid Vermont business trust, or, in the alternative, a valid Vermont private trust. The issue of whether a business trust or a private trust was created is relevant to this bankruptcy proceeding for the following very limited reason. 11 U.S.C. Section 541A1 includes in a bankruptcy debtor's estate, quote, except as provided in subsections B and C2 of this section, all legal or equitable interests of the debtor in property as of the commencement of the case. So when the case began, remember, he filed the case, the bankruptcy case in August, but he executed the trust and bought the property on behalf of the trust in 1987, a few years before, right? However, subsection B1 exempts from the property of the debtor's estate, quote, any power that the debtor may exercise solely for the benefit of an entity other than the debtor, exercising power, fiduciary power, trustee power, solely for the benefit of the C&H Associates Trust. That's what they're talking about, right? Which entity is hereafter referred to as C&H Associates Trust. Then any power James Gablehart exercised solely for the benefit of that entity would not be property of his bankruptcy estate. In particular, since the Carriage House property was found to be the res of the C&H Associates Trust, it's the trust property. Any power James Gablehart had over the Carriage House property, if exercised solely on behalf of C&H Associates Trust, would not cause the Carriage House property to be part of Gablehart's bankruptcy estate. I'm just going to chill on that right there. It's distinct and separate. A living trust, a grantor trust, will protect from probate. It's not going to protect property from bankruptcy. It's not going to protect property from litigation. It's not going to protect property from lawsuits. It's not. A private trust will, or what is called a valid business trust. A trust where the trust indenture is not registered, but the trustee's name is recorded, qualified as trustee on the documents, the ownership documents of the property. This is This is wild. First, Judge Conrad found the Declaration of Trust was a valid, signed expression of James Gablehart's intentions. This finding was not clearly erroneous. There is evidence that James Gablehart only signed the document on the advice of his accountant because he thought it would save him taxes. That's substantiation. That's, hey, man, I remember doing that because my accountant told me that, and I thought I would save some taxes. Regardless of not whether I save taxes or not, which is not the issue, and obviously I didn't with that accountant because he didn't know what he was talking about. It's still a separate and distinct entity, and I remember executing that indenture. However, James Gablehart did intend that the writing would bind him and that it would be legally effective, at least for tax purposes. So there it is. In this, Gablehart was attempting to create a real estate investment trust under 26 U.S.C. subsection 856. Judge Conrad found at trial that the C&H Associates Trust failed to qualify under this statute as a real estate investment trust. You got to understand the statutes. Well, some people, it's very common for a private trust to be created for business purposes such as this. This is very, 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 very common. Very common. The legal issue arises after the determination that the Declaration of Trust was a legally effective document, is whether the Declaration of Trust created an entity. Vermont case law gives little guidance on whether Vermont would recognize common law business trusts because it's statutory law. They ain't going to talk about common law too much. And Vermont statutes give no guidance as to whether it is possible to create statutory business trust in Vermont. I don't think it is. Judge Conrad conducted a lengthy analysis of whether or not the Declaration of Trust created a business trust, and then noted that even if the Declaration of Trust did not create a business trust, it still created a private trust. So there, the bankruptcy trustee disputes that a business trust was created. However, given the existence of the Declaration of Trust purporting to create a business trust, the question remains as to what, if anything, was created, even if a business trust was not. So they're saying because there exists a Declaration of Trust, regardless if it was the intention to create a specific trust, meaning a business trust or a real estate investment trust, because it didn't qualify for that particular type of trust, what was created? It still was a trust. At least in one case in a jurisdiction where business trusts are regulated by statute decided that when there had been an attempt to create a business trust, but statutory conditions were not fulfilled, a private trust was created instead. And I can tell you this, you can attempt to create a trust and not meet the statutory condition of including the state law in the governance. That's a private trust. If the trust isn't governed by state law, it will not meet state statutory conditions. So instead, it is a private trust. This is very simple, y'all. It's very, and I'm, for those of y'all who know this, I apologize. This is just a refresher. For those of y'all that are new to this, listen, it's not me saying this. I'm reading the Supreme Court case law. That's Article 3 courts, judiciary. There's no higher court judiciary or, adjudication than this. Cases decided in jurisdiction where business trusts have not been regulated by statute, but rather by the common law, also found that imperfect attempts to create business trusts still result in the creation of some sort of, quote, entity, end quote. I'm going to read that again. Cases decided in jurisdiction where business trusts have not been regulated by statute, but rather by the common law. Some people are like, well, this is a common law trust. I don't know. You might want to you have the common law right to contract unlimited. So you have the common law right to contract or create a contract, which means create a trust. I don't know if you want that governed under the common law, though. It's up to you, though. That's up to you. In fact, The bankruptcy trustee relies on Limousin for the proposition that no business trust was created. However, the argument of the bankruptcy trustee does not advance his position, since a private trust is also an entity under the bankruptcy code. Case is decided, just tearing up that bankruptcy trustee. However, the argument, I'm sorry. Cases decided in jurisdictions where business trusts have not been, wait, I read that already too? I'm not going to read that. However, as noted, the private trusts private trusts, partnerships, and unincorporated associations, as well as business trusts, are all considered entities under the bankruptcy code, since Judge Conrad found that the declaration of trust was validly executed and not void for public policy or other reasons. It created something. This something was unquestionably an entity for the purposes of the bankruptcy code, unless it was void for some other technical reason, and it wasn't. If the entity created was in fact a trust and not a partnership or unincorporated association, which it was a trust, there are two further technical requirements which it must satisfy under Vermont trust law. First, since the res of the trust was real property, the trust must be in writing. Done. There's a declaration of trust. Clearly, the declaration of trust satisfies this requirement. Second, if there was an identity of persons between the trustees and the beneficiaries, the trust would have been extinguished under the doctrine of merger. So basically, if the trustees and the beneficiaries are the same, that's a grantor trust. The grantor and the trustee is the same. The grantor and the beneficiary is sometimes the same. But this is where you get into hot water. When the trustees and the beneficiaries are the same, it's the doctrine of merger. Judge Conrad found that only James Gablehart was trustee. Y'all, pay attention. Whereas the holders of the beneficial interest were both James Gablehart and Ruth Gablehart. There is factual support for the finding in the record, and this finding was not clearly erroneous. Under Vermont law, the Judge Conrad found a trust does not merge where the trustee is merely one of the sesteque trustant, the beneficiaries of the trust. What is it? Sesteque is sesteque. What is that? It's Latin, right? One who has beneficial right or something like that. One who benefits from a trust, or one who has beneficial rights, or a beneficial right. I can't remember the exact definition. Y'all can correct me if you want, but that's what a sesteque is. And then the sesteque trustant is one who has beneficial right of a trust. It's Latin. I'm trying to learn it. Where we at? Let me get in here. Having reviewed the testimony, stipulated facts of the trial, we find that Judge Conrad was not clearly erroneous in his finding that James Gablehart was acting solely in his capacity as trustee of the C&H Associates Trust when purchasing the carriage house property. Gablehart did, after all, sign the warranty deed as trustee on the same day that he attempted to create the C&H Associates Trust. He did more than attempt. It's obviously a trust. Clearly, the C&H Associates Trust was in his and the losers' minds when the deeds were signed and title passed. Was it proper for Judge Conrad not to decide the mortgage discharge? Yeah, it was proper, since the time that Judge Conrad decided the carriage house property was not part of the estate. State court with proper jurisdiction has determined that the mortgage discharge issue it found loses mortgage on the carriage house property was not effectively discharged. Check it out. Because the discharge language had not been properly witnessed. I'm telling you, this is the trick right here. Oh, no, it wasn't discharged. It wasn't properly witnessed. Our analysis of the issues presented on appeal leads us to the conclusion that at least under sections 541A1 and 541B1, the carriage house property is not property of the bankruptcy estate. Since it is not, there was no reason for Judge Conrad to decide the mortgage discharge issue, and his decision not to determine the issue was proper. However, from the stipulated facts on the record, it is clear that under Vermont law, Had Judge Conrad reached the issue, he would have reached the same conclusion that was reached in the Vermont Superior Court, namely that the mortgage was never discharged. Title 27, Section 463 of Vermont statutes annotated. Governing the discharge of mortgages requires that a discharge be signed in the presence of one or more witnesses and be acknowledged. Someone very, very smart at that bank came up with this. And then the two women went along with it. I would put money on this. I will put money. They realized their mistake. They contacted the attorneys, and the attorneys figured it out. They figured it out. I'm telling you, while two persons, Cooley and Simmons, signed the mortgage discharge on the face of the mortgage, neither of them signed in the presence of each other or any other person, and therefore the discharge was ineffective. Oh, it was dirty because it was not signed in the presence of one or more witnesses. In such a circumstance, the mortgage is, under the plain language of the statute, still in force. Conclusion, y'all, having considered the issues brought before us on appeal and for the foregoing reasons given, the opinion of the Judge Conrad is hereby affirmed. They said basically, yeah, it's a trust. The carriage house property is res of the trust or corpus of the trust, property of the trust, not property of the bankruptcy estate, not property of Gablehart, either one of them, James or whatever. And that's it. This is one of the cases I studied a while back. It's kind of cool going back through it. And it definitely reminded me of my mentor, you know, definitely. But it's one of the cases that I reviewed, that I studied and was like, whoa, okay. And it was one of the first times where I felt confident in my trust knowledge because I was able to pick out the difference. Once I read that he was only the trustee, but he was also the beneficiary along with his wife being a beneficiary, I knew that was good. I knew he was good there. When they were talking about he tried to make this type of trust, I knew he was good because there was a trust declaration and I also knew that he was good when he signed his name and then qualified his name by writing trustee after that. That's what we do every single time. If we're writing a check on behalf of the trust, we're depositing a check on behalf of the trust. Anything that we sign in our fiduciary capacity, we qualify the signature because it provides those trust protections. So what do you do when it's the state versus your trust? If you have a trust that is properly executed with the proper jurisdiction, number one, and number two, it's properly administered by the trustees, you will likely be a party to a successful trust defense, because really they were trying to get the trust assets, man. And this is what they do. And they try to go after the validity of the trust, and they try to go after the administration, and whatever they can do, because the winning side it's worth it. Losing is just some paperwork and some time. But if we win, man, we get your assets. And that's what this game is about. They give us fiat currency. They give us equity, stocks, and so on and so forth in our 401k. These are non-tangible assets. No longer gold and silver in circulation. 5-year loans on cars. They're talking about 50-year loans on mortgages. Talking about you will own nothing and be happy. And anyone that can hear what we're saying here at the foundation, hearing is not enough. Action is required. Taking self-responsibility and action, taking responsibility for yourself and your family is required, because no one's going to run up to you and be like, hey, man, you look like a cool person. I know this information about trust. Just give me your information and I'll take care of everything and just send you checks, beneficiary disbursements. Not going to happen. Not going to happen. So, we got to do this on our own. This is something that needs to happen with our impetus. But here, the power is right there. You can research this, take a screenshot, whatever you want to do, write notes. You can pull this case for yourself. I know a lot of people like to use Google Scholar, but if you go down to your local law library, every courthouse has one. Ask them where it is. It's open to the public. You can walk in there free. You can jump on a computer, Westlaw or LexisNexis, and type in the case information, and it'll come up. You can pull it up. If you have a flash drive with you, you can download it on your flash drive. Otherwise, most law libraries allow for you to email the PDF file of the case to yourself. It's not as hard as you think. It just requires effort and action. But, these are some of the cases that you will be studying in trustee training, or this is definitely a case you'll study in trustee training. If you check this out, then you've got a head start. You got a little extra step, stutter step going. You feel me? No, I'm just playing. But this and more in trustee training, it's a very, very powerful structure. It's powerful for your family. The public does not want you to know about this. Attorneys do not want you to know about this. State tax authorities do not want you to know about this. Federal taxing authorities do not want you to know about this. Bankruptcy trustees do not want you to know about this. Creditors do not want you to know about this. Mortgagors do not want you to know about this. I can keep going. The IRS does not want you to know about this. The state IRS, Revenue Service, does not want you to know about this. I mean, I can keep going and going and going. When property is titled in trust, what's the difference? It comes off of the public rolls. What does that mean? Well, it's no longer available on sites like Zillow and all this other stuff. It changes the status. And that's all I'm going to say. That's all I'm going to say. We're going to end right there. I hope you learned something. I really do hope you learned something. Make sure you email us, admin@welcometothefoundation.com or support@welcometothefoundation.com. You got any questions? You want to take advantage of the half off of the sign-up fee for the trustee training? I recommend this one right here. It's the best value, the platinum, but you do your dance. You do your dance. This goes until next Friday, February 13th, Friday the 13th, because we are superstitious. I'm just playing. We're not. We're kind of, though. I don't know. What does that mean? I don't know. I don't think I am. I should stop playing with y'all because, we've been asked if we were, what would they ask us? What'd they ask us? We've been asked if we were Masons. We've been asked if we were part of a secret society. We've been asked some questions. So let me not play around because the answer is no. Absolutely not no. I would never take an oath to anything outside my family or the creator or love, truth, peace, freedom, and justice. Would never. You know what I'm saying? Especially not death oath. And I'm just not down with the weirdo stuff. Hey, I like the light. I don't like the dark. I go to sleep in the dark, man. Wake up, daytime. So, hey, trustee training. I be digressing, don't I? I'm sorry. Trustee training, do your dance. Email us to get signed up, or you can just sign up for the full price. But you have until February 13th, Friday the 13th, next Friday, to get your finances in order so you can, do your luxurious dance. And with that being said, I appreciate y'all checking out the show. I really appreciate it. I went live, had some technicals, but, the mic wasn't miking, no miceys. But y'all stick with me. I ain't got to tell y'all. It's all love. Y'all take care of yourself. Enjoy yourself. Make sure you say 10 things that you're thankful for before you go to sleep tonight and every night. It's very important. And I'll catch y'all in trustee training.